Hi, today's podcast video is on the impeachment of state officers in the state of California. It might not surprise you, but the California Constitution, like its federal counterpart, allows for the impeachment and conviction of certain state officials. The U.S. Constitution provides in its Article 1, Section 2, that the House of Representatives shall cause their Speaker and other officers and shall have the sole power of impeachment. Our California Constitution in Article 4, Section 18 specifies that the Assembly has the sole power of impeachment, and impeachments must be tried by the Senate. A person may not be convicted unless by roll call vote entered in the journal, 2/3 of the membership of the Senate concurs. Also in Section 18 of Article 4, it says that state officers elected on a statewide basis, members of the State Board of Equalization, and judges of state courts are subject to impeachment for misconduct in office. Judgment may extend only to removal from office and disqualification to hold any office under the state. But the person convicted or acquitted remains subject to criminal punishment according to the law. In addition to the constitutional provision in Article 4, Section 18, California's Government Code in Article 2 of Chapter 7 of Division 4 of Title 1, long enough, provides for the impeachment by the California Legislature. And here we have a number of government code provisions that are relevant. The first is Government Code Section 3020 that provides that state officers elected on a statewide basis, members of the Board of Equalization, and judges of state courts are subject to impeachment for misconduct in office, same as what we found in the Constitution. Section 3020.5 states that the Senate, when sitting as the court of impeachment, is a court of record, and the officers of the Senate are the officers of this court. Section 3021 of the Government Code specifies that all impeachments must be by resolution that were adopted, that were originated in and conducted by managers elected by the Assembly. Section 3022 requires that the managers are to prepare articles of impeachment and present them at the bar of the Senate and then to prosecute them. The trial of impeachment is to be before the Senate, which sits as a court of impeachment. In Section 3023, it states that when an officer of the state is impeached by the Assembly for a misdemeanor in office, then the articles of impeachment must be delivered to the President of the Senate, who is the Lieutenant Governor. Section 3024 requires the Senate to assign a day for the hearing of the impeachment and to inform the Assembly of that date. Section 3025 of the Government Code requires the Senate President to serve the defendant with a copy of the articles of impeachment with a notice to appear and answer at the appointed time and place. Section 3026 requires the service to be made personally upon the defendant, state officer. Section 3027 of the Government Code states that if the defendant does not appear, then the Senate may assign another day for hearing the impeachment, or the Senate may proceed to trial and judgment in the absence of that defendant. Section 3028 provides that when the defendant appears, that the defendant may object in writing to the sufficiency of the articles of impeachment, or the defendant may answer the articles by an oral plea of not guilty. Section 3029 requires the defendant to answer the articles, and if the defendant pleads guilty or refuses to plead, then the Senate must render judgment of conviction against the defendant. Section 3030 provides that if the defendant pleads not guilty, then the Senate must try the impeachment at the time that it appoints, and the plea is entered into the Senate journal. Section 3031 states that the Senate Secretary must administer to all members of the Senate an oath that's truly and impartially to hear, try, and determine the impeachment case. And no member of the Senate can act or vote upon the impeachment or upon any question arising as a part of that without having first taken the oath. Section 3032 specifies that the defendant cannot be convicted on impeachment without the concurrence of at least 2/3 of the senators elected. If 2/3 of the members of the Senate elected do not concur in a conviction, then the defendant has to be acquitted. Section 3033 states that after conviction, the members of the Senate must pronounce judgment in the form of a resolution that's entered into the Senate Daily Journal. Section 3034 provides that on the adoption of the resolution by a majority of the members present who voted on the question of acquittal, it becomes the judgment of the Senate. Section 3035 specifies that the judgment may be that the defendant be suspended or that the defendant be removed from office and disqualified from holding any office of honor, trust, or profit in the state of California. Section 3036 provides that if judgment of suspension is given, then during the continuance of the judgment, the defendant is disqualified from receiving the salary, fees, or emoluments of that office. Section 3037 notes that whenever articles of impeachment against an officer of the state are presented to the Senate, that officer is temporarily suspended from his or her office and cannot act in his or her official capacity until and unless he or she is acquitted. In Section 3038, it specifies that upon temporary suspension of any officer other than the governor, the office must at once be temporarily filled by an appointment made by the governor with the advice and consent, which is a vote of the Senate. The office is to be filled by the appointee until the acquittal of the party impeached, or if he or she is removed, then until the vacancy is filled at the next election. And then Section 3039 provides that if the lieutenant governor is impeached, then notice of the impeachment must be immediately given to the Senate by the Assembly in order that another president of the Senate may be chosen. And finally, under the government code dealing with impeachment of state officers, Government Code Section 3040 specifies that if the offense for which the defendant is convicted is also the subject of an indictment or information, then that indictment or information is not barred.